Hi friends, and welcome to the second class of jurisprudence. Today we are going to discuss about the nature of the jurisprudence and the scope of the jurisprudence. In all legal examinations, you will find any one question on either of them, all. It's possible that you can find a question on both of them because it's important for a legal professional to know about the nature and scope of jurisprudence. We should not speak random that jurisprudence is everything, whatever is related with the law. No, there are certain points which needs to be in mind when we speak about the scope of jurisprudence. So to capture that, I am here. So today when we'll start with the jurisprudence nature, we should know the different definitions of jurisprudence which are given by various jurists. That is which we have taken care in the last of the classes, and the crux of all those definition was that jurisprudence is the elucidation of general principles upon which actual rules of law are based. So here we see there are two important things to know: general principles of law and actual rules on which these law are based. So the same thing comes to knowledge when we speak about determining the nature of the jurisprudence. So, nature of the jurisprudence, if we see what is the nature, what we do, the first point comes in mind is analyzing legal concept. So, in jurisprudence, we analyze all the legal concepts. Then, the second point is we try to find out essential principles of law. So, we started with the concepts, then we go to the principles. And here, the principles are the essential principles of law, means the principles without which law cannot be understood. Then the third thing is analyzing already known rules, but also sets the foundation of the new rules. Please note that jurisprudence is not discovering the new rules. It's setting foundation for the new rules. It means analyzing already known rules and setting foundation for the new rules. And most importantly, the fourth point is it's a result of thinking of jurists and philosophers. This is a very important point to be known. Everybody cannot speak anything, and that will be recorded as jurisprudence. The renowned jurists and philosophers who analyzed and they gave their philosophies related to jurisprudence, that all is a part of jurisprudence. Now the next thing we should talk about is the scope of jurisprudence. What exactly jurisprudence cover? So in a single line I can say that jurisprudence scope is anything that concerns order in the state or society will be under the domain of jurisprudence. As per Radcliffe, as per Radcliffe, jurisprudence is a part of history, economics and sociology, ethics, philosophy of life. So these all, if you see the important spheres of life, they all are part of jurisprudence. Now, the difference of jurisprudence from the law, it's not the same actually. Samant says that in jurisprudence we are concerned with nature of legal rules, underlying meaning of legal principles, essential features of legal system. These all three. I'm repeating it. As per Samant, in the jurisprudence we are concerned with nature of legal rules, underlying meanings of legal concepts, and essential features of legal system. So hence, jurisprudence is comprising of philosophy of law, and its object is not to discover new rules but to reflect on already known rules. So it has to be kept in your mind that what jurisprudence is not. Jurisprudence is not discovering the new rules, but to examine and develop and reflect and analyze the already known rules. Now, what are the contents of jurisprudence? Jurisprudence typically is comprised of three things: the sources, the legal concepts, and legal theories. When it comes to sources, typically jurisprudence is the main stream of whole law from where all laws originate, and it's not a codified law. So the sources of jurisprudence, in light of this statement, there are two. One is the traditional, which is ancient sources, and another is the modern sources. The ancient sources comprises of all the religious literature, old thoughts. For in Indian scenario, it's Shrutis, Smritis, and what our Vedas says for Hindu law. But for the modern one, the legislation, precedents, judiciaries, all the records and all of their rules, their principles and their decisions, they all form part of the jurisprudence. So here I would like to touch base with what are the different schools of jurisprudence, because in the upcoming classes we'll be discussing about those ones one by one. The first one is the natural law school. The second is the analytical or Austinian or positive school. The third is the historical school of jurisprudence. Fourth is the sociological school of jurisprudence. The fifth one is modern law school, which is American realism. And here we'll take a touch base with the economic theory of law also. So this is all about the different schools of jurisprudence. And I would like to close this discussion with a famous saying, which is based on the Latin maxim that ignorance of law is no excuse. Means ignorantia facti excusat, but ignorantia legis name excusat. So the whole crux of studying all the jurisprudence and the studies is this fact that ignorance of law is no excuse. The last but not the least, let's talk about the importance of jurisprudence. Based on all the discussion which I had with you now, we can understand that jurisprudence helps to whom? It helps most to a lawyer, because it helps a lawyer on basic ideas and reasoning behind written laws. Because when we start our study to become a lawyer, we go through all the previous theories, literature, thinking of the jurist and philosophers. So this subject helps a lawyer to understand the basic ideas and develop a reasoning within him, that why we say so, why a particular jurist says so, and who criticize whom on what. So it gives us a sense of reasoning and an aptitude of reasoning. Apart from that, we understand fundamentals of law and figure out the actual rule of law. That is very important to know. We may be thinking something that it can be a judicial rule, but actually it may not be. So it's good to investigate, explore and think, but at the same time, we should confine ourselves to whatever is the existing theory of law. And then only when we will benchmark our thought, then only we'll be able to develop or innovate new things. Apart from that, judges or lawyers, they use jurisprudence as a guide to interpret the law. So they have to definitely innovate or explore, but within the boundaries of set principles of law. So this is the utility of the jurisprudence. So I'm concluding this now, and in the next sessions, we'll be talking about different laws of the jurisprudence, different schools of the jurisprudence. Thank you.